talking about trusts, and I want to thank Seugnette and Racquel for making themselves available on our ThinkLegal platform to come and talk a little bit about trusts and some of the pitfalls involved in trusts, and obviously in worst case scenarios, what happens when you have to litigate in terms of a trust. Today's program is going to be a little bit different than usual. We are not going to be doing slides today. What we are, however, going to be doing for our attendees, which I think most of you will find very, very useful, is we are actually busy compiling a bundle with all of the most relevant case law that Seugnette and Racquel will be referring to today in terms of their presentations as a bit of an aid memoir for you to also use within your own practices. Seugnette obviously will be talking about the creation, management and dissolution of trusts, and we'll also be looking at some pitfalls when it comes to trusts, your real do's and don't do's when it comes to administration of trusts. Thereafter, we will be joined by Advocate Racquel Andrews from the Johannesburg Bar, who will be talking about litigation involving trusts. Racquel is just, as we speak, in urgent court on a matter, so as soon as her matter has been dealt with, she will be joining us. In terms of recording for today's meeting, we will be recording it. We will still decide, once I've had a chance to chat to our speakers, whether we will be putting it out there on YouTube as a public video or a private video. But I assure you, everyone who has registered will at least have a private link to view the video afterwards. Just for purposes of housekeeping, obviously I'd like to thank some of the organizations which are supporting me in doing this ThinkLegal initiative. A lot of people, when I speak to them, say to me, how do you have time to actually do all of this? Don't you have a day job? And I assure you that I do have a day job, and Shantae, Lee, Kyra and company do that day job for me. So very, very warm welcome to those guys who are joining us from Vermeulen Attorneys. I see Kyra laughing. It's a bit close to home, isn't it, Kyra? Kyra being one of our senior candidate attorney at the moment. So thank you to all the guys from Vermeulen Attorneys, and then also Lawbox Practice Management Software, which is one of our partners who supports us in these initiatives. So let's get into it in terms of the subject matter for today. Before I hand over to Seugnette, I'm going to be reading an extract from an SCA judgment which was handed down earlier this year. The neutral citation, I don't even think this has made it to the law reports yet, was handed down on 28 July 2022. MJK versus IIK. Neutral citation is 2022. ZASCA 116, and in this particular case was on appeal from the High Court, where the respondent in the SCA had achieved an order for the trust veneer to be pierced, and the majority judgment, which was written by Zondi J.A. with Skippers, Mabinda, Bokwana, Matujani and Smith concurring, stated the following in terms of trusts. Trusts have for years been used and will continue to be used as a convenient tool for estate planning, and are governed by the Trust Property Control Act 57 of 1988. Section 1 of the Trust Property Control Act defines trust as being the arrangement through which the ownership in property of one person is by virtue of a trust instrument made over or bequeathed to another person and or beneficiaries, etc. And I paraphrase. And I believe that this is quite a groundbreaking judgment in that the SCA has to a large extent qualified what they've said in Badenhorst. Something that I see as a divorce lawyer very, very frequently is the minute you see a trust in divorce, very often people run to have the trust veneer pierced and saying that the assets must be brought into either the joint estate or added to the accrual. For this reason, I've reached out to Seugnette and Racquel to come and chat to us and, as it were, set the record straight in terms of trusts and their functioning, and really the pitfalls to avoid when dealing with trusts, so as to not put yourself or your co-trustees or your family in peril. As a piece of housekeeping, I will be monitoring and moderating the chat on the side. We are quite a large group of registrants today. I see we're about 50 people in the meeting at present. We have over 200 registrations, but a lot of those will obviously be on YouTube. But since we are a big group and some people are still joining up, I'm going to unfortunately have to say we're not going to use raise hand function today, just to stay within our time limit. If we finish earlier, then we can obviously open it up to the floor and have some debates. But for now, please, if I may ask any questions that you may have, please type them in the comment box. I am going to be moderating, and where it is a simple answer, simple, always inverted commas when it comes to trusts, I will answer. If it is something a little bit more complex, I will be putting it to Seugnette and to Racquel during the course of the webinar. Now, by way of introduction, Seugnette Schwim is an attorney. She is director of Schwim Venter Attorneys, being specialist fiduciary attorneys as well as conveyancers. And she is also, and I think today the hat that she's wearing is as a franchisee, and I don't know if it's just a franchisee, if I can say just in inverted commas again, with Wealth Succession. They are extremely busy in the realm of fiduciary work and estate planning. Seugnette has done extensive work with me in terms of assisting my clients with their estate planning post-divorce in terms of fiduciary, as well as a few cases where we need to make sure that all of the I's are dotted and the T's are crossed, even for people going through divorce. So I have immense respect and admiration for what Seugnette does, and I am certain that all of you are going to learn a great deal from what she has to say today. So without further ado, I'm going to hand over to Seugnette Schwim. Seugnette, you are still muted, so please do unmute yourself. This is going to be glorious. I get to actually spectate for once. Can't wait. Thank you so much, Seugnette. Over to you.
Thank you so much, Mervyn. Thank you for having me, and thank you for that lovely introduction. I have to say I'm sort of sweating under the table here after hearing all of that. So let's hope that I can offer something of value to the people dialing in today. And also just to note that the field of fiduciary law and specifically trust law is extremely complex and very much up to factual matters and case by case. So what I'm trying to convey today is very much theoretical, and I think once Advocate Racquel joins us, she might be able to bring in some of the juicy bits of actual litigation experience in that. But whatever I say may be open for debate, and I would like to welcome our attendees to do so through the chat line, as you said, so that we are able to open the conversation and get different perspectives in it as well. But I just quickly want to fix a setting here on my computer. There we go. So let's start. Thank you so much for that intro, Mervyn, where you set out basically what the Trust Property Control Act defines a trust as. And what I do in my mind, because I'm absolutely a picture person, is I look at the definition of what a trust is, and I bring it back, I take it back into the technicalities of the law, and then bring it back into the picture so that I can always remember what it is and how it works. And basically what it is we speak of it being akin to a stipulatio ulteriore. In other words, similar to, much like a stipulatio ulteriore, in the sense that it's a contract between two parties, a founder and trustees, in terms of which they want to benefit a third party, the beneficiaries. So when I look at a stipulatio ulteriore, which can be a very complex legal term and concept. And I bring it into trust law. I always see a triangle, because it always is these three parties that interact with each other for a very specific reason. And we'll go into some of that reasons and qualifications later on. But when you think of what a trust is, it's exactly that. It is one person, a founder or a settler, handing over assets or an obligation to trustees or a board of trustees that they then have to administer in terms of a trust deed or a trust instrument for the benefit of beneficiaries. So looking at these specific parties to a trust in this triangle, you have the founder or the settler or the donor, which is often the primary client or the estate owner or the wealth creator. But it's not always the case. And one of the issues that we have, and let's start in with a pitfall immediately, is the use of template trust deeds that are out, where everybody thinks that they can copy and paste a trust deed and sell it, and this is a great business. It's not. The use of template trust deeds and the misuse thereof, to the extent that you're exposing your client to a wide range of risks and pitfalls. And if you look at the parties to a trust, the first guy, the settler, the donor, the founder, he is often the guy starting, opening up the contract with the trustees. But what happens is in trusts, we've seen this often in trust sets up around the 70s and 80s, where this whole idea around secrecy of trusts, where the idea why you want a trust. If I have a trust, I'm able to hide assets. I'm able to own malls and not tell anybody about it because it's in the secret little trust nobody knows about. And because of the secrecy, what they would do when they set up the trust, they will ask the receptionist of the attorney setting up the trust to sign on the dotted line as the founder, because theoretically, once the founder sets up the trust, he should step away from the day-to-day role. So to ask the receptionist to act as the founder, in their minds, were not a big deal. But then what happens with these badly drafted trust templates is somewhere at the bottom of page 35, there's a clause that either deals with the termination of the trust, the distribution of trust assets, the amendment of the trust deed, where someone didn't check the deed, and it says if there are no beneficiaries alive at the date of the termination of the trust, or if this or that or the following happens, then the intestate heirs of the settler or donor or founder is to receive the trust fund. Then it can very well happen that the family's wealth that was supposed to be protected in this vehicle then goes out and pays out to the receptionist of 30 years ago, her family and her loved ones. So that's just a long story to say that the role of the founder is to set up the trust and to fund the trust initially, but that it is not something that really should be delegated. Because based on fallback schemes.
Great, thank you.
Sorry, Seugnette, I've just muted. Someone's mic was on. Folks, if I can please ask you just to keep your mics on mute so that we don't disturb our speaker. And Seugnette, you're doing great. You told me to tell you if you're getting nervous and you go too fast. You're doing great. Take a deep breath. I'm scared for your health. Maybe also switch your mic on.
You muted me. Okay, great. So we dealt with the founder, and then we've got the trustees. Remember, going back to this triangle, and I think if each of you put a 10 rand in a bucket on your desk during this next hour for every time I say triangle, then you'll be able to take your families out to dinner tonight. Because that really is what it's about in terms of understanding the mechanics of it. But in any case, back to the triangle, 10 rand in the bucket. The trustees. So the trustees are if we think about a company structure, it's the directors of the company. So the trustees of the trust are the people doing the administration of the trust, the day-to-day business of the trust that manages the affairs. But the trustees as such do not have a vested interest in the trust assets. It's possible for a founder to also be a trustee, to also be a beneficiary, and for a trustee to be a beneficiary and the other way around. So any one person can have all three roles. But the trustee, when he's wearing his hat as trustee, doesn't have any vested interest in the trust assets. He just does the work. He works for the trust. And we'll touch on it a little bit later, but it's important to have an independent professional trustee. Independent, firstly, because of the a master circular that was sent out in, I think it was 2017, that says you have to have an independent trustee when you have a family business trust. In other words, where the beneficiaries are related to each other, where the trustees are also beneficiaries, and where the trustees get a benefit from the trust. So there you have to have an independent trustee. The reason why I say it's important to have a professional independent trustee is, as you'll see from this discussion, there is a lot of technical compliance pitfalls in running and administering a good trust, a safe trust. And you have to have someone that knows how it works and how it operates. So you will get away with the criteria of having an independent trustee if you appoint your neighbor, because he's not a blood relative, he is not a beneficiary of the trust, and he's not related to any of the other beneficiaries or trustees. But that might just not help, because if your neighbor only knows about the bryflies but not about the trust law, the taxation law, dealing with donations, doing proper administration in terms of books of accounts and accounting statements and, then you're really just opening yourself up to unwanted risk. And even worse, you're opening him up to risk, because once you assume the role of a trustee, you are equally as responsible for whatever happens in that trust. Because remember, we are administering assets for the benefit of beneficiaries. These are innocent people that's trusting, hence the word trust, trustees to deal with the assets in the safest, most prudent way, so that they can continue to enjoy the benefits and reap the fruits. So the criteria to act as a trustee really is high, but the risk is even higher. So as colleagues around the table, I would like to really warn you to take up trustee positions, because it sounds like a nice fee, sounds like a cool gig, sounds important, because it really does open you up for risk. If you don't know what you're doing 100%, rather step away, because the risk and exposure is vast. Okay, then the third party to the trust, the triangle, is the beneficiaries. Now, the beneficiaries can be a class of people. In other words, I don't have to name my 3 children and my 10 cats on their names with their ID numbers in the trust deed. I can just say anybody born from my marriage with Pete, or whatever the case may be. Any person that, whatever, you can create a class. So you can describe the beneficiaries as a certain class of people, as opposed to naming them on their names, legal descendants, blood relatives, or my cousins, or whatever. It can also be a company or a trust. It doesn't have to be an individual. And when you then start to plug in companies and trusts, it becomes a whole organogram, which once you do complex estate planning, has its benefits and uses. And yeah, so it can be a bit, the nice thing to know about defining beneficiaries is, if you work with a class of beneficiaries, instead of stipulating them with names and ID numbers, is when it comes to the compliance load, because the compliance load in trusts are so steep. Every time you open a bank account, you do an investment, you do anything, you have to figure out everyone. You have to figure out the founder, which is also why it's difficult if you've appointed your previous attorney's assistant. You have to figure out the founder with updated figure. You have to figure out the trustees. If the trustee is a company, you have to be able to go back into the ultimate beneficial owner of the company or the trust, or whatever the case may be. And you have to figure all named beneficiaries. So if you have listed 10 heirs or 10 beneficiaries by name, you have to figure everyone. So what I'm just saying is, top tip, use classes. It just, eases the administrative load. Okay, so that is the parties to the trust. Next up is the different types of trusts. And here I'm going to deal with some of the questions that you have seen through during your registration process. And perhaps other questions might come up, which we can deal with as they come up. But in basic principles, in South Africa, we have either a living trust, an inter vivos trust, or a mortis causa trust, a testamentary trust. And one of these two, both of these two, can either be active trusts or dormant trusts. And there are different reasons to have them either active or dormant. But let's say, for example, one of the questions that came from one of you during registration is, how do you use a trust? How do you create a trust to save for one's kids? Now, first of all, we have to understand, let's just go back to what type of trust will that be? That would be an inter vivos trust, in other words, a living trust that's set up and registered now and starts to operate actively. But in the way that the question was posed, how do you create the trust to save for your kids? It needs to be remembered that a trust is not an investment vehicle in the sense that it's a savings tool. A trust is a vehicle where after you've saved, you want to put your assets somewhere to protect it and grow it and use it for a specific purpose. The cost of operating a trust over a year and then over 18 or 20 or 30 years is quite expensive, in that you have to pay your professional trustee a trustee fee annually. You have to pay an accounting officer for tax and accounting services. You obviously have to pay tax. You have to keep everything compliant. You have to operate a bank account. So to run an active inter vivos trust can be expensive. And the amount of money or assets that you place in trust for the other reasons that you want the trust for should justify the costs associated with that. So you won't want to set up a trust and then start paying in 500 rand a month or 1,000 rand a month to save for your children. You would want to set up a trust because you already have existing wealth or an existing plan of wealth. So let's say you're business, it would be better to set up the trust and start the company within the trust while the value of the company is still zero, because you know you're going to grow the company into something enormous and you want the growth to happen within the trust. Or you already have to have existing wealth to donate or transfer into the trust to justify these costs. However, if the question is perhaps rather, how can I safeguard my wealth for the benefit of my children should I no longer be there? Then possibly a testamentary trust would be a better option. So the testamentary trust is set up in terms of your will, and there are no costs associated to it until you actually pass away, and from your estate, your assets flows into your testamentary trust. There's no setup cost or registration cost because it is your will. It actually really is your will. Then maybe also just going back to the use of an inter vivos trust versus a testamentary trust. One of the questions we received was, what is the best trust to have if you are married in community of property? So you have to understand that the importance of a trust structure is understanding the fact that in that triangle again, the founder is transferring assets to the trustees to be administered for the benefit of the beneficiaries. So there's a clear separation. Once you set up a trust, there's a clear separation of ownership and enjoyment. You're giving away assets to an entity that is not you. So once you do that, how you are married is of no relevance anymore, because you are no longer the owner of these assets. So whether you're married in community of property or out of community of property is not relevant anymore, because you don't own these assets. You relinquish control of these assets. So that means the only thing that you have to keep in mind is to fund the trust. It happens in one of two ways. You fund the trust by donation or by loan account. So I donate R1 million to the trust, and on that I pay 20% donation tax, or I loan the R1 million to the trust, and then a loan account is created in terms of which the trust now owes me R1 million, and that loan account becomes an asset in my estate. And now, because it's in my estate again, the loan account, not the R1 million, the loan account in terms of which the trust owes me R1 million, that then is open to however way I'm married. If I'm married in community of property, half of the value of that loan account is obviously jointly owned by my spouse. If I'm married out of community of property with the accrual, the value of the increase of that loan account as interest grows becomes part of the value of my accrual claim. And then another thing is, as you either dispose or loan assets to the trust and you're married in community of property, keep in mind that your spouse in community of property would have had to consent to this transaction happening. So you have to give away assets, but if you're married in community of property, you have to consider your spouse and get their consent to do so. Okay. Then, of course, there's the option of having an offshore trust, and that can also be dormant or active. Offshore trusts, which are active, in our view, calls for wealth of approximately 8 million to 10 million rand upwards before paying fees in pounds or dollars actually becomes worth it. So that is just our personal advice to clients when they want to do an offshore trust, is paying the fees to run an offshore trust is extremely expensive. So only when you reach a wealth point exceeding 8 million, it really becomes worth it. But then a dormant offshore trust, or what we call a bottom drawer trust, and we call it a bottom drawer trust because you literally set it up now, don't really use it. You put it in the bottom drawer of your desk, and then one day when something happens, you pull it out and now you use it. It becomes active. And that normally happens in your will, where you say, I leave all of my assets to the offshore trust that was already registered 20 years ago. We didn't use it, but now because we're going to fund it with assets, it becomes active. One of the questions that came from you guys is whether a South African trust can own offshore assets. And the answer is unfortunately no. A South African trust cannot own any offshore assets. It is possible through complex structuring and Reserve Bank approvals and to do it, but a trust cannot directly own assets in offshore property. An offshore property an offshore trust, however, can own South African assets. And that is where the use of an offshore bottom drawer trust sometimes becomes beneficial, because you are able to take your estate offshore after your passing for the benefit of your children there, and it can still own your South African assets. So that is where that actually becomes a good option. Then in the testamentary trust side, a testamentary trust, and one of the questions from you guys was, what's the practical steps to actually set up a testamentary trust after a person passes away? So remember, the will of the client or the now deceased is actually the trust deed of the testamentary trust. So that will needs to be drafted 110% perfectly. You can't have, once again, a copy-paste will, and then that becomes a trust deed, and then the children is stuck in a structure for 20 years that, nobody thought through well because the will badly drafted. So the actual will of the person, then you submit the original will to the master's office when the person passes away, and to report the estate and start the estate administration process. Then you ask back for a copy of master stamped copies of the will, which you then send back to a different department in the master's office to register as the trust deed of this new testamentary trust to be set up. So the actual costs and registration process of a testamentary trust only happens after the person passed away, and the physical document is the will itself. A pitfall to keep in mind when it comes to testamentary trusts is that because the trust deed is actually a will, and it can never be changed because the person that drafted it is now deceased, it can happen that legislation changes, the family dynamics change, something changes, and in an inter vivos trust scenario, you would have gone to the master and had an amendment done to your trust deed. With a testamentary trust, you can't do that. That document is now the fixed deed. It can never be amended. So it doesn't offer a lot of flexibility in terms of planning for minor children because it's fixed. It's a good solution for people that have minor children that don't have another trust structure in place. If you have minor children and you have to bequeath something to them in your will, you have to use a testamentary trust if you don't have another trust in place, failing which the inheritance will go to the guardian's fund. So there's not a lot of options there. What you can do is use the offshore bottom drawer trust as well, if the value of the inheritance of the client actually makes it worthwhile. So testamentary trust for normal people is a good solution when dealing with minor children, but just take care to make sure that that will is properly drafted, has got an annexure of powers and responsibilities and whatever for the trustees, because trustees can only act in terms of the trust document, be it the trust deed or the will. Okay.
Great. Seugnette, can I interrupt you to go through a few questions?
Let's hope I can answer them.
Let's hope so indeed. All right. Seugnette, Karen Botha, attorney mediator, asks, what are the tax implications for the donor to trust? Obviously, you touched a little bit on the idea of either doing a donation and then there's donations tax, or putting it in as a loan account, which is really the two classical ways, I suppose, of getting money or assets into a trust. Are there any broader tax implications specifically focusing on the donor that need to be taken into account?
Definitely. So you're correct. When you're looking at the tax implications, you're looking at how the trust was funded. If it's done by means of a donation, it is exactly that. You pay donations tax, which is levied at 20%, but you get an annual 100,000 Rand discount on your donation. So you donate R1 million to the trust. First 100,000 Rand is a freebie, and then on the remaining 900,000 Rand, you pay 20% donations tax. If you fund the trust by means of a loan account, since 2017, the provision was introduced that a deemed asset is created if you don't charge interest on that loan account. So you borrow or you loan 1 million Rand to the trust, and a loan account is set up. That then, like I said, is an asset in your estate. And like anything else, if I give you R1 million, I'm most certainly going to charge interest. If you don't pay me interest, then the bank would have. So if you have a loan account to a third party at arm's length, you would have had interest charge. And so in 2017, they came in to say, but these people loaning money to their own trust are not raising interest on it. So in other words, the loan account is not growing with interest. In fact, it's reducing because they're using all sorts of smart ways to reduce this loan account. Because remember, ultimately, the idea is to cut the tie between your estate and the trust, with where there are no loan accounts at play. But okay, now you've got the loan account, and since 2017, they say you have to charge interest equal to the prime lending rate +1, and +1%, and then interest should be paid. If you don't charge interest, that would be considered a deemed donation. So donations tax would be charged on the value of the interest that you've foregone. So they work out what the interest would have been. You're not charging it, so they're charging you donations tax on top of that. So it's and that completely threw the industry, because everyone started to complain. And I think one of the questions we also got during registration is, what's the use of a trust anymore in any case these days, if SARS is so on top of them and it's this interest situation and it's just tax. And the answer is that, first of all, the implication of Section 7C is not that bad if you do the holistic planning for the right reasons, and you understand why you're setting up the trust. And we'll get into some of the qualifications, criteria of intention and a little bit later on. But you can actually, with the 100,000 Rand rebate, loan up to roughly, because the interest rates just changed last week, I don't know what the exact amount is, but roughly R1 million to your trust before Section 7C even comes in. Once it comes in, interest will be charged, and you can either pay the interest at your income tax rate, or you can say, I don't care about that. You can charge me a donations tax, which might be better depending on your personal income tax rate. So that is the tax implications on funding the trust.
Sure. Very interesting. I suppose it comes down to one thing is just run it properly for the purpose that the Act really prescribes. Then we've got an interesting question from Grant. Can investments in your name be donated into a trust? Obviously, I suppose it's different rules for different type of investments. If it's something that's purely discretionary to draw down from, like a unit trust, I suppose that makes it a bit easier than things like pension funds and annuities, Seugnette?
Yeah. No, definitely. So it all comes down to having a good accounting officer, because it's about how do you actually reflect what happens. So you can do almost anything as long as you can do it practically in your books of accounts, in your tax assessment. So yes, an investment can be transferred. So there would be a change of account holder from me to now the me trust. And in the actual paperwork of the trust, it will show that this asset became a trust asset by virtue of me donating it. So yes, it's possible. It will also depend, like you say, like certain investments will either not be possible or would not be wise. Like any retirement annuity, provident fund, pension fund, that wouldn't make sense to transfer. But also you can't actually transfer a retirement annuity to a trust because that's linked to you personally. In your working life. So, but in general, all types of investment bank accounts, whatever, you don't have to liquidate the assets, put it into cash, reopen it in the trust. But remember, when you do that, it will still have a capital gains tax implication because it's still a disposal of an asset from me to the trust. So even though the actual nature of the asset didn't change, it's still a disposal. So doing that won't really help you with the capital gains tax implications.
Absolutely. Contract law side of it, obviously one has to be very careful in seeding these things, etc., etc. All right, then we've got a question from VIP user. I don't know who VIP user is. What is reasonable remuneration for an independent trustee? Is there a statutory prescribed rate, or how is that calculated?
There really isn't a rate, and it is an open market situation. So when you look for an independent trustee, it's about shopping around. From corporate trustee side, you will realistically look at anything from about 12,000 Rand per annum to 35 or 45,000 Rand per annum. So obviously the 35,000 Rand, 45,000 Rand per annum is possibly for larger trusts, or for the, well, all trustees should be specialist trustees. But for when the trustees quote, they will quote on the size, risk, and complexity of the trust. So if you have a trust that only owns a holiday property or a rental property, it's one asset, it receives 8,000 Rand in rent per month, that's it, then the trustee will quote you closer something closer to 12,000 or 15,000 Rand per annum. But if you have a massive trust with a lot of businesses that operate and earn a lot of revenue, and the risk is so much bigger, then you can easily look at 45,000 to 50,000 to 60,000 Rand per annum. So it is dependent on the type of trust, the risk, and the work to be done, the hours to be spent.
Fantastic. Thanks, Seugnette. And then final question, then you can go on with your with the remainder of your presentation. Corin asks, do you nominate replacement trustees in the will, or do you need to make provision for it in the trust deed? I think that's something which a lot of people are unclear on, and something which Louis actually canvassed with us, I think, a week or two back, is where the will fits in. And isn't it a case the will really becomes the trustee, doesn't it?
The issue is, and maybe that will become clear in the next section where we start to discuss a sham trust and an alter ego trust and the Badenhorst issues, is at which point does it become, where I prescribe something in my will, do I become someone that actually tries to control the trust? So to answer the question easily, yes, you can nominate replacement trustees in your will. There's a whole standard clause for it, and the testamentary reservation in the trust deed says that the founder or the trustees can appoint replacement trustees in the will, and then in the will side stand. So it exists and it's possible. From our side, and the advice we render is not to do it, because if you're creating a link between your estate and your trust, you're drawing attention to a trust showing that I think I'm the boss of this and I'm trying to control this. And I'm so scared that I'm going to die. I have to make sure who's going to look at it, look after the trust after I'm gone. And by doing that, you're creating a set of facts around you which shows that you're not really letting go of the control. And because it's so important for a trust to succeed, to say that you did let go of the control and the trustees are independent, we don't like doing that. So we will never advise our clients to do it. We never do it. But technically and practically it's possible, and a lot of people do it. But those are the reasons that I won't advise on it.
Fantastic. Thanks, Seugnette. Those are the questions we've got in the comment box. I'm going to look on some of the other platforms on the Excel and on WhatsApp, whether there are any further questions. And then after your next section, I'll put them to you. Also, I'll probably phone Rex and frantically find out how urgent is going.
At school.
Speak very slowly.
Okay. Okay. So just before we go into the really exciting bit, which I really am quite passionate about, and I think would be most interesting to everyone around the table, is there's one extra question that came from the registration process that says, I'm going to read the question to you. But what happens if upon the death of the first dying in a joint will, married in community of property, a trust needs to be set up and the surviving spouse does not agree to the terms of the joint will, but concludes a single will thereafter? Will the trust still be set up, and what must be done to avoid that? Does the conclusion of a further will actually means that she repudiated the current will? So I'm not sure if everyone followed that. They're asking, in a joint will, marriage in community of property, a trust was set up. Now it's time, the first dying spouse passed away and the trust needs to be set up. But the surviving spouse says, no, I don't like it. I'm not into it. What's the processes? So what needs to be understood here is that there's a difference between a joint will and a joint estate, firstly, and I'll explain what that means now. And then furthermore, there's also a difference between masting, or in Afrikaans boedel samensmelting, where individuals that owns two separate estates joins their estates and then deals with that as a massed estate in terms of their will, which is a complex estate planning tool. And then there are certain implications of that. So the first thing is joint will versus joint estate. If you're married in community of property, you've got a joint estate. In other words, we have one bucket of assets, and of everything in this bucket of assets, we each own an undivided half share of that asset. So he doesn't own the chair and I own the table. I own half the chair, half the table, half the spoon. He owns half the chair, half the table, half the spoon. So that is an in-community of property estate, and that's a joint estate. But then you have a joint will, which is something totally different and does not relate to how you are married at all. Mervyn and I can have a joint will, which is basically we have one will that sets out what we want to do with our assets once we pass away. We're not married. We're not going to leave anything to each other, but we have a joint will. So a joint will simply means one document. But what you determine in that one document still comes back to the implications of what type of estate you have. So if the joint will says, I bequeath my estate to my neighbor, then if I'm married in community of property, that would mean 50% of my joint estate. If I'm married out of community of property, my entire estate. So the wording of the will in terms of joining sentences does not apply to how the actual estate is made up of, depending on your matrimonial property system. So in this question, there's a joint will and they're married and a joint estate, so they're married in community of property. And at the death of the first dying, the husband set up a trust. Remember, he set up a trust for his estate. You are still alive, so your half of your joint estate remains is still yours, and you will receive that back from the estate during the estate administration process. So the whole joint estate will go into a deceased estate. Your half would be broken off and given back, and then only the will be read, and the will say, I leave my entire estate, in other words, 50% of my joint estate, to the trust, wada, wada, wada. Now, the spouse in an in-community estate cannot change that, because that was the will of the deceased person. So that's the first answer, is to understand the difference between joint will, joint estate, and the fact that as a co-owner in a joint estate, you cannot change or repudiate or whatever the will of the first dying spouse. However, if it is a massed estate, the will says, at the death of the first dying of the two of us, we elect to mass our estates, make it one, and then a trust should be set up, and this and that and the following should happen. Because the surviving spouse is still very much alive and well, and still has an undivided half share in her assets, she can then say, I do not accept the terms of the master estate, and I do not consent to that happening. And the result is that the will should make the provision if my spouse does not aviate in terms of this will, in other words, accept the structuring that we put out in terms of massing, then this and this and this will happen. So the will guide you in terms of whether the trust should be set up or not. If we're talking massing, it's something totally different from just saying I've got a joint estate and a joint will. What now? Joint estate, joint will, just simply say I cannot change the will of my predeceased spouse, so his half of the assets will go where he wants it to go. I hope that answers that. The person that sent that through, if that didn't answer it, you're welcome to contact me and I can just take you through the steps again, or even review the will with you. Okay. Just take a sip of water for a second. Now, this is where it becomes really, really interesting. And like I said, where most of you will get the benefit, or would have seen it in industry through mediation and practicing as attorneys, is the big issue around whether a trust is a sham trust or alter ego trust or whatever that entails. And the big issue here is that we, as an industry, have a very wrong way of speaking. And technically, it's really bad in that we speak easily, but the implications of what we're saying is not accurate at all. So if you have a sham trust, you cannot have an alter ego trust, and the other way around. They are mutually exclusive, and I'll explain to you why now. But if we look at the Badenhorst versus Badenhorst case, which I'm not going to go through the facts again, I think most of us around the table now know the case very well, have dealt with it in the past. I know in the past webinar where I've been involved in, we've referred to it as well. And maybe Advocate Racquel will refer to it as well later on this morning. But I'm not going to go into the facts. But in summary, what happened is there was a divorce proceeding, and the spouse asked the court to bring in the family trust assets into the divorce proceedings for purposes of the redistribution order. And the court then did that. They ignored the trust and they brought it in, and they awarded, the benefits to the spouse as per request. And that is why, as practitioners, we always come back to Badenhorst versus Badenhorst, because it's actually, before you understand it, it seems shocking that the court would ignore the trust structure and bring it back into litigation procedure. And the reason for that is, if you go through the actual factual findings of the case, which we're not going to do now, it comes back to the fact that the husband had too much control over trust assets. He pretended like it was all his. He dealt with it as he pleased. His co-trustee was his brother, and he never consulted his brother on any decisions. He just did what he pleased. And then the court basically said, in better words, it said, oh, you like pretending like it's all yours. Don't worry, we will do the same. You like making, playing like it's all your assets. So we will include it in your estate and your wife can have a share of it. So what they basically did by doing that is they say we should go behind the trust form, or disregard the veneer of the trust, or pierce the veil of the trust, or treat the trust as the alter ego of the trustee or Mr. Badenhorst. And those are all different ways of saying that they are ignoring the existence of the trust and they are bringing all the assets back into the hands of the trustee, mismanaging it. Obviously, you would have been the founder as well to get that done. So the important thing to say here is everyone then went and said, okay, Mr. Badenhorst's trust was a sham. No, it was not a sham. When the court said we're going to ignore the trust structure, we're going to pierce the veil of the trust, by saying that, they already acknowledged that a trust existed. There was a trust. Mr. Badenhorst, through maladministration and too much control, misused the trust, and now they're ignoring the trust, bringing it into divorce proceedings. But there's a trust. When we say a trust is a sham or a simulated transaction, we're actually saying there is no trust. So where a trust is a sham trust, there's no trust. So then wanting to ask whether it's an alter ego or not doesn't exist. You cannot have an alter ego trust for a vehicle that's not really a trust. So a simulated transaction or a sham actually comes from the idea where parties have an idea of an agreement that they want to enter into. So we have an idea, this is what we want to do, but you know what, let's disguise it as something that it's not. Let's make it look and smell and whatever like something similar to a trust. Everyone will think it's a trust, we'll call it a trust, but in reality, this is what we actually want to do. So they're simulating something and disguising it as something that it's not. Obviously, this is done intentionally, but oftentimes also because of lack of knowledge and proper advice, this just happens through maladministration. We'll come into the day-to-day administration steps later on. But it's something like saying a rose by any other name is still a rose. It's similar to say a trust is not a trust just because you call it a trust. You cannot place the word trust on anything and say it's a trust. It can be a partnership, it can be an association, a joint venture, whatever. It can be anything else. It's not necessarily a trust because we call it a trust. So we have to put it through the tests of what a trust is. In the case of the Commissioner of SARS versus NWK in 2010, which is a tax case with complicated facts surrounding loans made and different agreements entered into. It's quite complicated, and I'm not going to go into it now. But in relation to tax matters, the court made two very important statements that we then carry on in this understanding of what is a sham trust. And they said there's nothing wrong with one or a person arranging your affairs in a way as to avoid some sort of liability or to gain some sort of advantage. So what they're saying by that, and it comes back to what Mervyn said at the very beginning of the session, that it's acknowledged that you are allowed to use the law to your advantage. And if the act or the law gives you an opportunity to arrange your affairs in a way that creates a tax benefit or enjoyment benefit or whatever the case may be, go for it. You're allowed to do it. So it's not frowned upon. And good, prudent, holistic estate planning is exactly that. It is using the law to my advantage. But the court then came in with a second very important sentence or statement where it said, the court will not be deceived by the form of a transaction. It will rend aside the veil in which the transaction is wrapped and examine the true nature and substance. In other words, just because you place a stamp of a trust on it doesn't make it a trust, and we will ignore that and look at the substance of what this really is. What did you try to do? What was the benefit that you tried to create? And aside, over and above what you're trying to make me now think it is. So that is where simulation or sham comes from, is when you're doing something different from what it is, trying to distract. Okay, but now, to decide if a trust is a sham, and if a trust is a sham, there really is no trust. Remember that. If a trust is a sham, there's no trust. And that then solves a lot of the other problems. But there's 5 essentialia of a valid trust to be set up, or criteria that you have to go through. And these things are they're very theoretical, but the reason I mention are so important when you actually consult with clients to make sure they understand these 5 things. If they don't buy into it, then a trust isn't for them. You're going to waste their money and time, and you're going to land them into trouble. What we do during what we call legal trust audits is we go through the trust deeds and the surrounding and see if these 5 elements are present, to say, let's just see if we worked. If it's not a sham, it's a trust. And if it's a trust, then we can look into maladministration issues or protection vehicle options. But the first one of the criteria is, did the founder have the intention to create a trust? Intention. Looking at that triangle again, and now from McDonald's, you're going to Spur now already by the time of use. Understand that by giving that away, I am relinquishing control, power, ownership, everything that goes along with that. And then the trustees will hold and safeguard the assets for the benefit of the beneficiaries. So is that what I wanted to do? Was that my intention? And this is where it's so important when you advise clients to tell them, look, if you do this, the benefits are great. The benefits are awesome. But you're going to no longer be the owner of the assets. There's no more saying my house in plate. It's not your house. You might, at best be a beneficiary that has an opportunity to perhaps have vacation in plate, not your house. You have to relinquish control. You're not going to tell us what to do. You have to know that the assets will be administered in terms of the trust deed, because if it's not in the deed, the trustees doesn't have any powers. Trustees are pretty useless in that sense that, I don't know if any of you read the Trust Property Control Act. I think it is 9 pages with the cover page included. It's the shortest, most simple act you'll ever read. You can read it during lunch this afternoon, so quick and easy. So the powers of a trustee really comes from the trust deed. And if the trust deed is silent or the trust deed doesn't provide power, then the trustees doesn't have the power. So you need to know that these assets which you handed over will be administered in terms of the trust deed, not in terms of what you think should happen, in terms of the trust deed. And where the trust deed creates discretionary powers to the trustees, then they have a little bit of a, within the scope of the trust deed, they can apply their discretion to make certain investment decisions and whatnot. But yeah, first qualification or first essentialia is that the founder or donor or settler have the intention to create a trust. Most importantly, if there's no intention, there's no trust. Then there's something else. And what was his intention? Partnership, association, whatever. Okay. Second one, was the founder's intention to create an obligation? So remember, triangle, handing over the assets to the trustees, for the trustees to accept those assets and say, I'll take this office, I will administer these assets for the benefit of the beneficiaries, is an obligation. And that's also why a trust deed will have a sentence in it to say something like, the donor donates assets to the trustees for the benefit of beneficiaries, and the trustees accept the donation. In other words, I accept the obligation. I understand the office of trustee, and I understand that by taking this asset, I have to do certain things with it to protect and safeguard it for the heirs. And that is an obligation. So did the founder actually have the intention of creating the obligation? If you are asking your brother, in Badenhorst's case, to just sit there and pretend to be a trustee because I need your chair, I need your signature, but don't stress about what's going on in the trust, then I'm not giving him an obligation. I'm actually opening him up to risk, but I'm not giving him an obligation. I'm just making a dummy out of him physically. So yeah, is there an obligation? And then number 3, can the trust property be defined with reasonable certainty? And you will know, if you've ever paged through a trust deed, there's that ridiculous little sentence of saying, I donate to the trustees, the first donation of 100 Rand. And then everyone's like, 100 Rand, ha, ha, ha. That is such a crucial, important clause in a trust deed. And if it's not there, you've got major problems. because we need, first of all, for the donation to have happened, for the obligation in criteria number 2 to have succeeded. But secondly, for the assets, trust assets to be defined, that 100 Rand is the first asset of the trust. And once the trust is registered, a bank account needs to be opened, and the founder physically has to pay in the 100 Rand. And very few people actually do it because 100 Rand, it's, you know, funny money. It's important, and it should lay on your bank statement, the 100 Rand. And in your annual financial statements, it should show that the capital of the trust is 100 Rand. And that is also that we are able to define the trust assets. And the trust deed will go on to say that the trust assets, 100 Rand, is able to be added to and taken off during the course of the duration of the trust. So that's where then later on you transfer a property, you do this, you do that. So are we able to easily identify and reasonably, with reasonable certainty, identify the property of the trust? That's that 100 Rand trick. And in general, if I walk into your living room, I want to know if your TV is yours or the trust. It sounds ridiculous now, but as a trustee, you need to know, even as a beneficiary, as far as you are aware of the matters of the trust, you need to know that car, that boat, that house is trust property. It's not Pitt's. Because if it's Pitt's and he pretends that it is, then once we've determined whether this is a trust or not, we'll go into alter ego issues. But okay. Then the fourth criteria is what, can the trust object be defined with a reasonable certainty? The object, as in, what is this trust meant to do? Why was it set up? And one of the things, if you look at the idea of transferring assets to the trustees for the benefit of the beneficiaries, is who are the beneficiaries? If I give Mervyn my car to, let's make it something more interesting, or whatever, money, to protect, and I don't tell him for who to protect, just Mervyn, keep this £1 million for me, and I don't tell him why. Then the question is, why? What's the object of this transaction? What are we doing? But if I say, Mervyn, take my £1 million and please grow and protect it for the benefit of my cat, then we know the object is for the £1 million to be kept for the cat. So an example of knowing what the object of the trust is also to know who the beneficiaries of the trust are. So the beneficiaries, like we said at the beginning, can be a class of people or people or institutions or entities, or name, institutions, entities, or people named by name. And what is something that creeps into badly drafted trust deeds, for example, is a clause that says, I direct my trustees to choose beneficiaries, income or capital beneficiaries from the ranks of my siblings. No, my siblings are my trustees, and they're all trustees. Whether they all benefit equally, that is up to the discretion of the trustees. But if I give my trustees the power of appointment to say, out of this broad class of people, you get to choose who the beneficiaries are, then the question is that my object of the trust is vague and unclear, because now I've given you the £1 million, and I said, okay, Mervyn, take my £1 million and please take care of whatever sort of cat you see in the neighborhood, but you choose. I've got no issue with what cat it is, you choose. So then it becomes vague. What's the object? What's the use of this trust? And so it's important for the founder to clearly set out the objects, but along with that the beneficiaries are clearly identifiable as one of the examples. And then the fifth criteria, which I'm not going to go into because it's so obvious, is the object lawful? I mean, I can't set up a trust for the benefit of an institution that's meant to go out and murder people, whatever. I'm not even going to think of other examples, but the object must be lawful, clear and simple. But okay, if any of these 5 fail, you don't have a trust. It's a sham. It's not a trust. It's a partnership or a business, won't be a company or whatever. And if that is the case, then we can't look at alter ego issues as in baden-washed. But if I have all 5 of them, the trust is valid, then we can't talk about a sham or a simulated transaction anymore. Then within a valid structure, the question becomes, did I misuse trust assets? Did I misuse my power? And then we look into alter ego issues. So basically alter ego, I'm just going to briefly touch. I think you all know exactly what that is. As in Badenhorst, an alter ego implies a trust or a, well, a trust, because we've now said it's not a sham, it's a trust. The trust exists. Mr. Badenhorst uses the trust as an extension of his personality. It's his alter ego. He pretends like it's part of him, it's connected to him. He's the hero in the story. It's his alter ego. And then the court, for example, in Badenhorst came in to say, if that's what you think, then we'll all play along. You bring it into your estate. And to determine whether a trust has alter ego issues or is misused as structure to extend the personality of the trustee, that is where the qualifications then come in with regards to proper administration. And we can maybe go into the day-to-day administration in a second. We can just take some questions first. But basically, then now that we have a trust, if someone alleges that I'm misadministering the trust, maladministration, whatever, then the court can come in and pierce the veil, ignore that structure, what, because we've established that there is a structure. Okay, Mervyn, I don't know if you've got questions at this point before we go on to the administration side.
Awesome. Yeah, so no, thanks. And I see Racquel has just logged on. Welcome, Rex. I hope and trust your urgent went well. You're here in like the nick of time. It's fantastic. I see we've got one question. Then we can go into the day-to-day administration, and then we can go over to Racquel from there. And the question comes from Grant. It's actually a very interesting question. I think it warrants some debate, because it really, I think, is a very situation-specific answer that you're going to probably give here. And the question is there a significant benefit in a trust versus only a will married in community of property with a child or children, comparing tax implications versus costs of running a trust? I think that really the big kicker is your estate duty, I suppose.
Well, the first thing is when you have minor children, let's just start with minors versus majors. If you have minor children, you don't have a choice into setting up either a testamentary trust or a living trust or an inter vivos trust, simply because someone needs to safeguard their assets until the minors become major. And that would preferably be someone in, I want to say, private practice, as opposed to sending it to the guardian's fund where you have to go and stand in a queue every month to get your payout. So if you have minor children, it's not a question, it's a must-have. In general, if you have minor children, you have to have that will in place. So that's the first. If you have major children, now the question is the use of a testamentary trust or an inter vivos trust necessary for tax purposes? And the biggest thing there is, a family should only pay estate duty on a certain set of assets once. So dad has an estate, he leaves everything to mom. Bequests to your surviving spouse are excluded for estate duty purposes currently, and that's fine. Nobody cares about estate duty, but now mom passes away and she needs to leave everything to her now major children. And depending on the size of the inheritance, we might say it's not necessary to do a trust, but if the estate at that point is larger than 7 million, in other words, every person pays estate duty on assets exceeding 3.5 million. But if you had a predeceased spouse that didn't use their primary rebate of 3.5 million, you are allowed to deduct it as well. So you get a deduction of 7 million, your 3.5 million and theirs 3.5 million. So if the estate at that point in time is larger than 7 million, estate duty becomes applicable. And 20% of everything up to 30 million is then estate dutiable, or is then estate duty. And everything exceeding 30 million, on that you'll pay 25% estate duty. So now in mom's estate, this will happen, doesn't matter if she leaves it to a trust or the children or whatever, and she pays that. Okay. She pays the 20 or 25% estate duty. Now the assets are in the children's name. They were working individuals. They have already bought their own house, grown their own estates. Now they get an inheritance. And for the next 20 or 30 years, that grows. And when they pass away in the same instance, estate duty once again. So we say we don't want such to be an heir in your estate. So to go have the same asset flow through private estates twice and have such take a piece of the cake every time, 20% is a large piece of cake, then yes, then you've wasted money, because if mom only put it in a trust back then where the children are the beneficiaries, then she would have still paid the 20%, but when the children then pass away, it wouldn't have become applicable. I don't know if that makes sense, but that's the reason why going into trust is beneficial. It's just because you don't want to pay twice, but that would be for an estate larger than 7 million.
Absolutely. Excellent. Thanks, Seugnette. Then I've got one more question, and this comes from Emmy, and I think what her question boils down to is, what is the tax implication to a beneficiary when it comes to a distribution out of a trust? I think that is something that is often overlooked, because you can't just make a distribution and the beneficiaries get it parcella, as far as I understand it.
Yeah. So first of all, maybe since all of these questions are tax related, I should just take the opportunity to let everyone know I'm not a tax advisor. So I'll answer the question, but just put a little caveat in, I'm not a tax advisor. So on case-by-case examples, please go and see tax practitioners. But in general, from a trustee situation or from a fiduciary specialist view, how that works is tax is paid within the trust. The trust pays income tax, for example, at 45%. So income that grows within the trust is taxed within the trust, and your capital gains tax rate obviously is linked to your income tax rate. And all of that happens within the trust. If tax is paid in the trust, a distribution made to a beneficiary is then post-tax, so the beneficiary doesn't have to pay tax on it. If you receive it as a distribution from the trust, it's free from tax because the trust already paid at the highest possible rate in our law. But the trust has the option through the conduit principle that if a beneficiary is at a lower tax rate than the trust, so anything lower than 45%, so most people are below that, then the trust don't have to pay the tax. They can distribute the assets to the beneficiaries pre-tax, and then the beneficiary has to declare the receipt in their personal income tax return and pay at their personal marginal rate. So it's one or the other, not both, and it will probably depend on who's at the lower rate, the trust or the beneficiary. That's it.
Fantastic. Thank you, Seugnette. Right, Seugnette, let's quickly just talk some housekeeping.
Yeah.
How much time do you still need in terms of administration of trusts?
I really don't want to, probably 5 minutes. I just want to run over it very quickly. We actually touched a lot on during the talk we've already had. So 5 minutes.
Fantastic. I think just to give everyone's brains a little bit of a breather, if I can just run a little bit of admin, I'm just going to copy paste into the comment box. Our upcoming events for the rest of the year, we've got 3 more events coming up. The first one is next week, the 5th of October. Chartered accountant and mediator Stella Kutsia is going to be assisting me. We're running a very, very practical lunch hour session called How to Calculate Accrual Claims. And Stella's going to be doing a few examples of how to calculate the accrual. It's from 1 o'clock to 2 o'clock, so it's something nice to do whilst you're having lunch. Then I'm doing my SARM accredited Children's Act deep dive on the 14th of October. It's a day-long session. It's 750 Rand, which includes your course pack. And we've got 3 spots still available for that one. That one's filled up quite nicely. Then on 4th of November, I'm doing a workshop together with social worker and mediator Adele Marie Volmerans on parenting plans. It's a half-day workshop for 300 Rand. The registration links are all in the comment box. And then finally, for those of you who are family practitioners, whether you are a mental health practitioner, an attorney, a mediator, an advocate, a financial advisor who specializes in divorce, if you work with families, I do invite you to join our ThinkLegal Family Law WhatsApp group. We are just over 200 family practitioners, and we share knowledge on a daily basis. I promise you, you will not get spammed. I am quite vicious with people spamming the group. So please do have a look at those, and please do feel free to join us with one of our other workshops coming up. On that note, Seugnette, if you would like to go through the admin side of things.
Thank you. So it's quite a comprehensive. I mean, if you're paying someone 45,000 Rand a year to do it, then you'll hope it's quite comprehensive. It's very comprehensive, the day-to-day admin of a properly run trust. But in like 5 bullet points, I'll just let you know some of the issues. So everything we've discussed up until now, the sham versus the alter ego. Let's put the sham aside. We now have a trust. We have an, now we're at risk of an alter ego. The question is the trust being run properly as a trust? And that is how you protect your founder and your trustees, because you're doing it properly. And doing it properly means keeping proper record keeping. So minutes for meetings, resolutions for every single decision signed by all the trustees, proper record keeping of everything that transpired, bank statements on record. All trustees should see all the bank statements every month. Proper books of account. At any time, if a beneficiary approaches you and wants to see books of account, you have to be able to show them how the trust assets are being administered, where they're invested, how does the income work, how does the distribution work, proper financial statements. Keep in mind, not all trusts have to be audited, so you have to have proper annual financial statements on every single trust every year. If you don't do it, you will get into trouble. But not all trust financial books needs to be audited, and that will depend on what your trust deed says. So also, as a trustee, know your deed. Don't take up an appointment where you don't know that deed off by heart. You will need to know what every single power and responsibility and duty of a trustee is. And one of those may be to have the books audited. It may also not be. It's also a cost-saving thing if it's not necessary. There are certain types of trusts where it is necessary, but just see what your requirements are there. You have to have a separate bank account for the trust. You can't mix the trust assets with your own assets, and it comes back to one of those valid trust criteria where we said, can trust assets be ascertained with a fair amount of certainty? If I have trust money in my own personal bank account, then you won't be able to know what is mine, what's the trust's. So a separate, proper bank account is a must-have. And then proper resolutions and voting to matters in according to the trust deed. So if the trust deed calls for majority decision or unanimous decision, that all needs to be recognized in properly written up resolutions signed by all of the trustees. Annual meetings needs to be kept up depending on the trust deed. Once again, it can be once per annum, twice per annum, every month, whatever the trust deed says. And proper minutes should be drafted and circulated for signature. Circulation for signature is important because the trustees needs to acknowledge that what is minuted is what actually transpired, and this is what I said and this is what I didn't say. And then just going lastly back to the alter ego issue, when you look at a trust deed or the trust documents without looking at the surrounding information, pitfalls would be if the trustee or founder trustee has a veto right to, supersede any other decision. He can hire and fire trustees as he pleases. He cannot be fired. For as long as I'm alive, I have to be a trustee. And of course, that testamentary reservation, which we refer to, those are all signs of one individual having too much control. So remember, the founder can be a trustee, can be the beneficiary. There's no problem with that. But you can't have one individual exercising too much control to the extent that it seems like he's pretending like it's his or her own assets. So that's it from the administration side. There's really not much more to say because it depends on the deed and it depends on knowing, proper trust administration. Like I said at the beginning, don't take a fee to be a trustee if you don't know what you're doing. It's very specialized. And then just very quickly as a closure from my side is to say that you should have a trust. People with business assets, people trying to protect and grow money for multi-generations because you're not stopped by an estate falling open and assets being frozen. People with children, keep in mind if people have offshore children, having a South African trust is not always the best structure. That's where some of the offshore trust options comes in. And then people that actually did prudent estate planning and understand the real reason for a proper trust to be set up. Clients that should not have a trust are those that think it's going to hide assets, it's secret, it's not. With our common reported standards, nothing is secret anymore. It's all public domain. And then, of course, those that come in to say, I want to trust because I want to save on tax. Long gone are the days where trust is a tax-saving mechanism. If used correctly, it can have great tax benefits over a long time. It's not going to be within the first 3 or 6 months. But if that's their primary goal, then a trust isn't for them because they simply don't have the mentality to understand everything that we've discussed today, including that triangle. And that was just me giving you a milkshake for tonight. Thank you, Mervyn.
Wonderful. Thank you, Seugnette. Folks, that is Seugnette Schwim from Wealth Succession. What a fantastic overview on the day-to-day of trusts. Folks, you will see I have pasted Seugnette's email address in the chat bar. From my side, I do, and if you will indulge me, given that we are trying as far as possible to keep these webinars free. None of our speakers get paid for giving of their time. So I do think you will forgive me when I say to you, please do get in touch with Seugnette. She is really, really excellent at what she does. Please feel free to email her if you have any questions that you have not really had the answers to so far in today's session. So that was Seugnette Schwim, estate planning and fiduciary specialist from Wealth Succession. Joanne says, gosh, that was brilliant. Seugnette knows her stuff. Thank you. Absolutely. I really, really have no reservations in recommending Seugnette to any of you attending today, whether you are an attorney, a man on the street, a businessman, or the like. Please do get in touch with her. She has indicated that she is open to being spammed by email. So, without any further ado, we're going to go into the second portion of the webinar today. And for that, I would give a very warm welcome to Advocate Racquel Andrews, who is fresh from her stint in urgent court and telling me on WhatsApp that she is having a hell of a day. I've had the benefit of consulting with Rex a few times this week, and she really is having quite a tough week. Racquel, are you ready for us? Have you got your camera on and mic on and ready to rock and roll?
I'm ready. Thanks, Merv.
Fantastic. So by way of introduction, ladies and gentlemen, please give a warm welcome to Advocate Racquel Andrews, practicing advocate from the Johannesburg Bar. I've had the benefit of working a few trust matters with Racquel in my day. We're currently working a hell of a trust matter, and I must actually say in front of everyone, Rex did save my bacon on the matter at least twice in this week on giving additional input and giving some ideas on how to handle the matter to the benefit of the client. Racquel is going to be talking to us about litigation involving trusts, and specifically, you know, as I said in the beginning of this webinar, we have this wonderful case that's now emanated from the SCA, NJK versus IIK, which really kind of tells us don't throw out the baby with the bathwater when looking at trusts. It is a legitimate and convenient tool for estate planning. However, Racquel was at pains to point out to me earlier this week that it doesn't do away with situations where the trust form is abused. And obviously, Racquel, you're going to be chatting a bit more about that. So very, very, very big thank you from my side. Still making the time to do this webinar today, despite having been in urgent court earlier today. I really, really do appreciate it. And our attendees today really, really do appreciate it. So without further ado, over to you, Rex.
Thanks so much. Thanks, everybody, and welcome. I'm sorry for starting late today. Urgent court, unfortunately, took preference. So trust and litigation, I think, is a very interesting topic. And I think it's difficult in the sense that a lot of people don't know how to approach the inclusion of a trust in a divorce matter. And for me, I have the benefit of dealing with divorce matters and involve trusts. And for the first point of call, we really need to take the step as whether we need to join the trust in the beginning or not. And as a starting point, because the party considering the joining of the trust doesn't really know at this stage or shouldn't know, or if they're not a trustee, or if they are a trustee, should know the ins and outs of the trust, it is always to the advantage in a divorce proceedings to join the trust to the divorce proceedings in order to investigate whether that trust should be held accountable, in the sense that should the trust assets be considered to form part of the estate of the parties. So to begin off, let's talk about what involves the trustee. So in terms of the Trust Property Control Act, the trustee doesn't become the owner of the trust property. It just holds the trust property for the benefit of the third parties. And these third parties are, for example, the beneficiaries. Now, in the Badenhorst case, which I'm happy to share the full citations with you later on, perhaps Mervyn, we can put it in a message and send that by email to all the parties later on.
Absolutely. We are working on the bundle as we discussed, Rick. So what I'm going to do is the bundle of case law that you will be referring to, we will have an indexed and paginated one sent out early next week with the reporting.
Wonderful. Thank you. So in the Badenhorst case, they confirmed in this case that the alter ego was one of the factors the court considered to determine whether to include the assets in the calculation of the estate. So the question the court asked was whether the assets are de facto part of one of the estates of the parties, and this is to be determined for the purpose of the accrual claim. What one needs to do when litigating in terms of a trust is one needs to seek a declaratory order that either the trust is a sham or that the trust is the alter ego of the trustee. And this means that the trust assets then are de facto vest in the estate of one of the parties, this being the trustee. So if you're going to proceed with the trust as a sham, note that you are then indicating to the court that no trust in fact exists. If you're going on the other hand and indicating to the court that the trust is the alter ego, you're confirming the existence of the trust, but merely now piercing the trust veneer to look behind the trust and then include the trust assets as part of the party's estate in the divorce. So in terms of alter ego, and that is really majority of the cases in including the trust in the divorce, that it is found to be more in line with what is being dealt with in terms of how the parties manage the assets. So just because there's mismanagement of the trust doesn't give you is not the sole reason now to join the trust. The trust assets vest in the trustee, and you need to then prove through your claim that in administration of the trust, there was an unconscionable abuse of the trust form through fraud, dishonesty, or improper purpose. That would justify looking behind the veneer. You cannot look at one aspect only, whether he had sole control of the trust, whether he put his personal assets in the trust. You have to look at that sentence that I've just read, and I can read it again. You need to prove in administration of the trust, was there unconscionable abuse of the trust form through fraud, dishonesty, or improper purpose. That would justify the looking behind the veneer, and that needs to be pleaded. If you do not plead that, and that was exactly what the problem was in the recent case that Mervyn has just indicated, the MJK case in the SCA, the appellant failed to plead that in her particulars of claim, and the quota quo unfortunately extended beyond the particulars of claim and went into the test for alter ego. So in the Badenhorst matter, it dealt with the redistribution in order, and actually in terms of Section 7.3 of the Divorce Act. What happened in this case was the trust was created during the marriage, and the plaintiff claimed that the trust was the alter ego of the trustee. The trust assets and the farm were regarded then as the trusts in the respondent's estate. That's what she wanted to prove. The parties were married out and out and had an A and C. The respective estates grew, but what the quota quo considered was because they started off the way their marriage started off, it could almost be deemed as a universal partnership. The respondent benefited more from their joint labor as his net value doubled in the estate. And in this matter, he was then ordered, in order to even out the parties' respective estates, 400,000 rand to be paid to the applicant to bring the parties on equal footing. So they didn't essentially look at joining the estate and considering the trust, to be part of the estate. What they did in this matter is the judge in the quota quo merely considered that he had to bring the respondent up in terms of her monetary contribution to equal that of the applicant. So there was no factual basis to include the trust assets, and it failed on his reason to do so in the applicant's estate because he wasn't equal in his estate to the respondent because they both started off in the marriage on the equal footing. His estate was allowed to grow because she worked on the farm, but what he did was he put the entire working farm into the estate, and at the time the parties were about to get divorced, he would leave the marriage with a greater estate than the respondent. And that is exactly why the judge looked at the matter afresh and decided rather bring a redistribution order instead of finding that the trust was the alter ego. He didn't find that the respondent abused his powers, and he didn't find that the assets that the trust owned and acquired were acquired through the means that were prejudicial to the marital estate. Then comes the SEA, and the SEA held that the mere fact that the assets vested in the trustees didn't form part of the estate of the respondent's estate does not exclude them from consideration when determining what must be taken into account when making a redistribution order. Therefore, it held to include trust assets, you need to give evidence that the trustee controlled the trust, and but for the trust, would have acquired and owned the assets in his own name. So we must remember when we litigate in respect of trusts, you must lead the necessary evidence to show that A, the trustee controlled the trust de facto, and that he would have acquired the trust, and but for the trust, would have acquired and owned the assets in his own name. What the court in the Badenhorst matter also did in the SEA was that they defined de facto control and de jure control. So de facto control is the founder has control over the trust, whereas de jure control is the control by trustees and the possibility and possibly appoints, the founder possibly also appoints through the trustees, close family and friends. So essentially what happens is in the trust, the trustee is actually in sole control of the trust and can elect what, when, and how to control the assets in the trust with no accountability to any other trustees. You also need to look when litigating on trusts at the trust deed itself, and this is imperative in litigation proceedings against a trust. So often people forget that your trust deed is the most important piece of paper when litigating against trust because it really sets out what are the duties of the trustee. What does he have to account for and account to in terms of the trust deed? How many meetings must be held and what resolutions must be signed in order for him to act and dispense with trust assets? From the evidence in the Badenhorst matter, the applicant had full control of the trust. No regard was had to the difference between trust assets and his own assets. And that is where the quota quo failed. The evidence, but for the test, ownership in all the assets vested in the respondent. So what the SCA found in this case was that he had full control of the trust. No regard was had in the difference between his assets and the trust assets because he managed the trust assets as if they were his own. And it was evident that but for the trust, ownership in all assets would have vested in the respondent. So the question we must look at when litigating in trust is whether trust assets can be taken into account for a redistribution order as well. So don't close your mind and only look at an alter ego. Look at other possibilities in terms of the Divorce Act. And that's when the case of Jordan and Jordan was also referred to. They determined that the trust treated assets of the trust as the trustee, treated assets of the trust as his own. Therefore, in a marriage out communal property with accrual, for the purpose of a Section 7(3) in terms of the Divorce Act, trust assets treated as their own should be treated as if it is in the defendant's own personal property. So once again, remember, your alter ego is not the only mechanism to join the trust. It can also be a mechanism in terms of a redistribution order. So what did the SCA deal with in this case? It indicated that the court misdirected itself in that the trust assets should have been added to the value of the respondent's estate. It also misdirected itself in stating that the assets at the beginning of the marriage was zero. Remember, at the beginning I said the court wanted to put them on equal footing because they went into the marriage from a clean slate, as the court said. The respondent actually brought into the trust a fully fledged working farm in this matter, and that fully fledged working farm was the source of the party's income and a material factor in this case. But the respondent and the applicant worked on the farm together. Despite that, the respondent's asset accumulated at a much larger rate than the applicant's. So what the SCA did was then they took into consideration the parties' respective contributions to the maintenance of the estate and how their respective estates increased in value. The trust assets as a result of the respondent having the full control of the estate, the fact that he regarded the trust assets as his own personal assets, was evident that the trust had to be included in the estate of the respondent. And for that reason, it was proved that the trust was actually the alter ego of the parties, and the trust assets were to be included in the determination of the means of such party for purposes of exercising the discretion in terms of a Section 7(3) redistribution. So remember, when we litigate, don't always limit yourself to just the alter ego. Extend it and go broader in terms of also including a Section 7(3) redistribution. We then have the issue of in community of property estate. Now, in terms of that and in terms of including a trust within in community of property, there is a case law, an SCA judgment, which I found, where we cannot now obviously use a redistribution discretion here. And I refer to the case of WT and others versus KT, and that's the 2015 3SA, and I'll also give that reference to Merv. What the court in the SCA had to determine was whether the discretionary family trust can be regarded as an asset in the joint estate. Now, I don't agree with the findings of the SCA judgment, and I'll give my reasons therefore later on. So essentially what happened was a trust was established in 1999 in this matter, and it was established on the premise that the father of the trustee, the husband, indicated to his son to establish this trust. The parties before they were married were living together, and the plaintiff made false representations, according to the defendant, to her that the immovable property would be registered in the trust to protect it from creditors, and that both of them, the plaintiff and the defendant, would be beneficiaries. This unfortunately didn't happen, and the plaintiff excluded the defendant as a beneficiary from the trust, as well as therefore excluding her from her 50% entitlement to the joint estate. A property was purchased and it was put into the name of the trust. As a result thereof, because it was in the name of the trust, the defendant was already disadvantaged because she wasn't going to receive 50% of her portion of the immovable property. What the defendant did was was that she pleaded that the trust was the alter ego. As a result of, the plaintiff was not the true intention to establish trust as an entity separate from the joint estate. The plaintiff had de facto control of the trust. The plaintiff regarded the trust as a financial vehicle in that he and the joint estate could amass own wealth and have financial advantage. The plaintiff, but for the trust, would have acquired and owned the asset of the trust in the joint estate, and the plaintiff always controlled the trust. The trust purchased the property in 1999 and was registered in 2000. The parties at this stage were not married, but were occupied and lived in the matrimonial home in this property for a period of 10 years. As I've indicated, the trust was created on the advice of the plaintiff's father. The father was the founder. The plaintiff and his brother were the trustees, but the brother was merely a trustee in name in that he didn't exercise any control over the trust. And the children were the only beneficiaries. Now, what's important in this case is there were no children in terms of the parties' marriage. No children born of the marriage, so no beneficiaries in fact existed in this trust. In 2010, the parties instituted divorce proceedings, and the trust, what came out there is that appeared that the trust purchased property to the value of this property to the value of 500,000 Rand through the bond. The plaintiff, remember they married in community of property, lent 100,000 Rand to the trust in an interest-free and no fixed repayment terms. Loan account was created against the trust and the plaintiff stood surety. The plaintiff used the funds inherited from his father once his father died thereafter to settle the bond in early 2001. At this stage, the parties are still not married. However, despite paying off the bond, he chooses not to cancel the bond and increases his loan accounts significantly during the remainder of the period until the divorce proceedings. The plaintiff's evidence was that he drew money from the trust account to the benefit of the joint estate. His salary went into the trust when needed. No resolutions were ever passed. His brother was a mere trustee in name and had no intention of interfering with the affairs of the trust, and the trust was controlled by the plaintiff. The court, it was held, has a discretion whether or not to determine if the assets belonged to the trustee or whether the assets should form part of the joint estate. So the SCA looked at this, and the question was whether is the trust the alter ego of the plaintiff. Now, unfortunately, the SCA found against the defendant in this case because they indicated that the defendant failed to lead evidence of this deceit or misrepresentation that she was ever going to be a beneficiary or trustee. No evidence was led to suggest that there was a consensus between the parties that she would have been a beneficiary. The defendant didn't provide any capital to purchase the immovable property, and the joint estate benefited from the use of the trust estate. No evidence that the plaintiff deceitfully took steps to preclude the defendant from her entitlement to the 50% of the joint estate, as the parties the SCA held were not married at the time when the trust was created, and the conduct, therefore, could not have been motivated by a future divorce. No evidence would have been that she would have been a beneficiary. The SCA found that this was improbable because the father was the founder of the trust and that the parties were not married at the time. So the court found her submission that she would have been a beneficiary improbable. It's evident, therefore, the SCA is applying a strict approach in this matter on how to pierce the veneer of the trust and determine whether the trust is the alter ego. What I find is that the SCA fails to take cognizance of the following. What were the circumstances that led to the creation of the trust with regard to the purchasing of this immovable property and the establishment of the companies of the plaintiff? So what is evident in the establishment of the trust and the purchasing of the immovable property is that these parties purchased the immovable property for their own benefit, for it to form part of the joint estate, because why? They lived in this house and they contributed throughout the 10 years of living there as much as they each could. They also didn't look at the status of the assets, and if they found that they would have fallen into the joint estate, then the trust shield should have been disregarded. So because these parties are married in community of property, what the parties bring into the marriage before and during the marriage should be deemed to be part of the joint estate. The SCA doesn't look into that. They merely close their eyes and apply the strict approach to say, well, they weren't married at the time of the trust being created. It's improbable that she would have been a beneficiary. And the trust was used for the benefit of the joint estate because the trust didn't charge them rent in terms of the parties living in the immovable property. What's interesting here is because, and this is another reason I find the SCA is incorrect, is because the beneficiaries never existed. How is it that the trustees acted in the best interest of the beneficiaries when dealing with the trust assets? They could not. There were no children. Therefore, because the beneficiaries didn't exist, what was the benefit of the trust? What was the purpose of the trust? It didn't have a purpose as per the trust deed. So once again, we look at the alter ego. And establishing whether there is an alter ego, we must remember to lead evidence that but for the trust, would the assets have fallen into the estate of the trust, or would they have fallen into the estate of the trustee? If they would have fallen into the estate of the personal estate of the trustee, yes, we need to pierce the corporate veil, not the trust veil. So now we ask the question, and I go back to, is it a trust? Is it a sham? How do we plead this, and what do we need to prove to the court in order to succeed? A sham is really indicating to say that no trust actually exists. So you don't pierce the veneer of the trust because no trust in fact exists. So there is nothing to pierce. If you have a look behind the veil, one has to recognize the existence of the trust in the legal sense and challenge the control of the trust. You have to look at acts done and documents executed by parties and whether these documents and acts done are in fact a sham, which intend to give a third party the appearance of a trust. So not that we're accepting the trust, it's you creating the appearance of a trust. And that appearance creates rights and obligations between the parties. But because of the fraudulent conduct of the parties in a sham, no rights and obligations are actually ever created, and therefore no trust actually exists. Whereas in an alter ego, what was found in the Land and Agricultural Bank of South Africa versus Parker, they held that if a trust formed is debased, justice would dictate that the veneer of the trust be pierced in the interest of creditors due to the unconscionable abuse of the trust form through fraud, dishonesty, or improper purpose. This will justify looking behind the trust form. So you really have to look when litigating whether, if we're going to pierce the trust veneer, is it due to an unconscionable abuse of the trust, and whether that unconscionable abuse is through fraud, dishonesty, or improper practice. So in order to determine that, we need to look at, are we deceiving third parties? Was the trustees appointed to comply with some of the formalities to create a trust? So look at your trust deed. Really look at how were the trustees appointed and what are their fiduciary duties, and do they comply with these duties? The trust property is treated as if personally owned. You need to lead evidence and you need to plead this in your particulars of claim or your counterclaim. that the trust property was created as if personally owned by the trustee. Then one or more trustees actually usurp so much power that they control the trust in such a manner that they directly benefit without consequences or answers to creditors. So what that means is that they have absolute control of the trust. They can amend the trust deed, they can distribute benefits, they can control the assets of the trust as they please, with no consequences for or answering to other trustees or creditors. And the mere purpose of this is the purpose of the trust is then defeated, because the purpose of the trust is actually to protect the trust assets for the benefit of the beneficiaries. But if the trustee, who has the ultimate power, is merely controlling those assets for his own benefit, there is no purpose of the trust anymore. Then we look at the administration of the trust, and that is again coming back to what does the trust deed entail? And this is each case is judged on its own merit. We cannot apply a hard, fast rule, but what we can apply is you must look at how the administration of the trust has occurred in line with the trust deed. Then we have a look at what contradicts the principles of the trust. Is the trust property, once again, separate from the trustee's personal assets? And you can only look at that if you have the trust bank accounts, if you have a detailed knowledge of how the trustee went about dealing with the trust and executing his fiduciary duties. Did he comply with his fiduciary duties or not? Did he transfer personal assets from the joint estate or from his estate in order to prejudice the estate of the other party into the trust estate? So the question is, has the trustee created the trust as a vehicle to secure private assets in that such assets would form part of his personal estates? So then what we have a look at, let's look at the MJK versus II case in the SCA, the recent case in the SCA. Now, unfortunately, in this case, what stood out for me was that the mere fact that the respondent failed to plead properly, and that the quota quo simply went out of its boundaries in terms of the finding that the trust was to be included. So the respondent definitely pleads that there's no difference between income and expenses of the trust and M. I'm going to call him M, her husband. He had solely managed the trust. His personal friend, Mr. Van Rooyen, who was appointed as an independent trustee. The trustee gave M full discretionary power. He managed it without third parties' influences. The ANC didn't exclude the assets of the trust. And this is a very important point because you can exclude certain assets in the trust in terms of the ANC. No difference between the assets of the trust and the CC and the assets of M, and the trust gave her funds for groceries, etc. She claimed that the trust established was to prejudice her in the exercise of her right to claim in the accrual. But once again, what happened in this case? She failed to plead that the trust acquired assets with the fraudulent and dishonest intention of avoiding its obligations to account for such assets, or that the trustee, acted dishonestly or in an unconscionable manner. Now that was where the case unfortunately falls apart for the respondent here. And the quota quo tried to come to her assistance and went beyond the pleadings. The SCA unfortunately found that quota quo was not entitled to do that. The respondent pleaded that she also wanted to join the trust because she too contributed more than her share during the marriage to M, and she was therefore entitled to a share in his entities. So in this matter, there are three trusts. Trust 1 and 2 were formed in 1999, where M was actually the sole trustee of the trust, until later in 2009 he was joined by Van Rooyen. And then Trust 3 was formed in 2011, and M and the respondent and Van Rooyen were trustees, and M, the respondent, and the minor child were in fact beneficiaries. What was the reason for the trust? And this is another important aspect you need to lead your evidence on. Why was this trust created? And in this case, it was held that the trust was created merely for estate planning and for tax purposes, and to protect the assets of M. Now, the issues, as I've already indicated, one, the particulars of claim didn't define in terms of the alter ego test. Nothing was untoward in establishing the trust, and there was no ulterior motive in setting up the trust. So the trustees' conduct invites the inference that the trust form was a mere cover for the conduct of the businesses as before, and that assets in the trust in fact belong to the trustees, where the trustees act in breach of their duties imposed as per the trust deed. So once again, it keeps on coming back to how is the trust being managed? What assets are into the trust? How do those assets become part of the trust or transferred into the trust? You need to look at that. You need to plead that evidence. You need to plead that in your particulars of claim, and you need to lead that evidence in your trial. Because without forming that basis, you're not going to be able to prove that the trust is in fact the alter ego. The trustee is the alter ego of the trustee. Therefore, look at the trust deed. Determine, control, and consider the evidence on how the affairs of the trust were concluded during the marriage. Also, don't forget about redistribution. The respondent also didn't consider redistribution as an option in this matter. So let's look at the conduct of the trustees when litigating. Let's look at how and when were assets transferred into the trust, and were these assets transferred from the personal estate of the trustee. You must also deal with assets as if they were, did he deal with the assets as if they were assets of the trust? Once again, with the fraudulent, dishonest purpose of avoiding his obligation to properly account to the respondent in terms of the accrual. So you have to lead evidence on fraud, dishonesty, and an attempt to avoid being held accountable in terms of his obligations for the accrual of the estate. So does he try and intentionally defraud or prejudice the respondent's claim in the accrual? And how does he do that? Does he transfer assets out of his personal estate? When does he do that? How does he do that? Is the respondent aware that he's transferring the estate? And what does she do with that information if she is aware? We must not forget that if both parties are trustees, both parties have fiduciary duties in terms of the state, in terms of the trust. So you cannot turn a blind eye if both parties are trustees, because both parties therefore have fiduciary duties. So looking at these aspects and what evidence we need to prove in litigation and what we need to plead are all with the object of concealing assets in the trust. Therefore, again, we must plead and we must leave evidence on unconscionable abuse of a trust through fraud, dishonesty, or improper purpose. That is the only test which justifies the court looking behind the trust veneer. So then, to recap, is the trust a sham or an alter ego? Look at when the trust was created. Look at the intention of the founder of the trust. Look at your trust deed and whether your trustees are performing in terms of their fiduciary duties. Look at the nature of the trust and why the trust was established. Look at how assets are transferred into the trust and where those assets are coming from. So if there's any questions, that is my presentation.
Yeah. Rex, awesome. What a thorough summary of litigation against trusts. I think we will definitely go into some questions. You've finished with your presentation 12 o'clock sharp. Damn well done. I don't know if you're watching the clock, but that is some seriously great timing. Seugnette, are you still with us? Do you mind joining us with your camera and your speakers on? I'm going to also add the spotlight to you. We do have a few questions. Guys, I know we are running a little bit over time, but for those who are wanting to stay on for the Q&A session, please do. Before I go into that, we started about a year ago with the ThinkLegal moniker and starting to do some education sharing initiatives, and we've really decided as a firm to keep it going. And actually, Claire, I see you are in the meeting today. Claire Waldeck actually approached me a while back and said, listen, why don't you actually consider trademarking the whole thing? No worries, Rex. She approached me and said, look, why don't you do a trademark? And that's actually what we've done. So you'll see in our emails, we have the little TM there. And thank you, Claire, for approaching us with that. So why am I telling you guys this? Well, because we want to keep the conversation going. If you are an attorney, an advocate, a mental health practitioner, and you have something that you're particularly passionate about, and you have a story to tell, please do get in touch with me. I'm going to share my email address with you, and let's see if we can put a webinar together. We will be looking at some new webinars early next year. So before we go into our Q&A, I would really like to thank Racquel for an absolutely awesome presentation on litigation on trusts. Seugnette actually made the point that actually is so beautiful how it flows in to one another, that we speak very loosely as practitioners and we say it's a sham and an alter ego, and you really beautifully set it out. That's not the only requirement. There are various things. In fact, the two are mutually exclusive. It cannot be a sham and an alter ego at the same time. And then obviously the abuse of the trust form set out so beautifully. Racquel, thank you so much. Once again, for those attending, I see a lot of attorneys in the audience, and if Racquel does it, she's touting. If I do it, I'm just sharing. I work with Rex very frequently. Really one of the best work ethic advocates I've ever seen. I really appreciate working with you and being able to draw on your wealth of information. With your permission, I will share your email address as well to attendees if they'd like to get in touch with you. And thank you for giving of your time and your expertise to enrich the platform. Valerie Scher, also advocate under KZN Bar, his wonderful presentation on litigation, and I must absolutely echo that. So guys, I'm going to pose a few questions to both of you, if it's okay with you, and let's get a little bit of a discussion going on these things. I've got one or two questions in the comment box, and a few also outstanding from the Excel on our registration form. One of the first ones, Bhavani asks, how would you cite a trust and the trustees? I've answered in the comment box. You simply cite the trustees, nomine, and officio. Do you guys have anything to add to that? Any pitfalls that we need to be careful of, Rex?
There is an SCA judgment which says that, I know some people cite the trust by accident, but the SCA held in that matter, if it is an SCA, I'll just confirm that it is irrelevant. They can amend and you can just carry on with the litigation and simply just cite the trustees thereafter.
Fantastic. Thank you so much, Rex. Then Cornay Stander, mediator, asks the following. Can an independent person request information on a trust if they suspect dishonesty? Racquel, obviously, we know in litigation, you can do your subpoenas duces tecum and you can request discovery, but this I find very interesting. I'd actually like to pose it to Seugnette, if you can help us with that. An independent person, a third party, will they be able to request information from the trustees? Have you seen this in your practice before?
No, It differs from an estate where a deceased estate has got certain periods of lying for inspection, inviting the general public to come and review and ask questions. A trust doesn't have that, and furthermore, you also have issues with property and information security. So an independent person that's not a beneficiary and doesn't follow the proper legal route cannot just come up and ask for statements of accounts and information. What is public domain, however, is the names of trustees on a trust. But the actual trust deed also is available at the master's office, so the file can be ordered, I guess, but details with regards to distributions and financials would be protected.
Sure. Excellent. Thank you.
If I can add to that,
yeah.
I think it also depends, and I think that the case also deals with it. You also have to have an interest in the matter. So just because you are a trustee or a beneficiary, you also might be a third party contracting with the trust. And that as a third party, you might want to now determine whether the trust is actually acting in terms of its trust deed. The trustees are acting in terms of the trustees. So you may be able not to just simply request the information, but you are definitely entitled to bring an application to court to then determine this.
Absolutely. Absolutely. Folks, I'm copying, pasting Racquel's email address as well, so please do take note of it in the chat box. Then I see we've got another question from Bhavani, which I'm going to go into shortly, but I've got a very, very interesting question from Barry from Mediation Academy. He asks, I have to compile a divorce settlement agreement where a trust is present. This is a first for me. What do the actual provisions in the contract look like? And this is something I think that really is open to a lot of debate. Can you really bind a trust when it comes to a divorce settlement agreement? And if so, would the trustees then ratify the settlement agreement? How long is a piece of string, I suppose, eh?
Yeah, I think your trustees can definitely ratify, and they can almost, like, when you have a party that's a party to the proceedings but not joined, they can do a notice to abide, so to speak. So you can definitely ratify the trust. I think the actions of the parties in the settlement by the trustees, but I do think it would be more beneficial to join the trust to the settlement agreement.
Absolutely. Thanks, Rex, for that. Then let's go into Bhavani's questions. They say we do levy collections, and a lot of the time a sectional title property, i.e. the unit, is in a trust. Do we liquidate or sequestrate a trust? What other method can we use to proceed against the trust if we cannot obtain the details? Sure. Obviously, the master being quite difficult to deal with in getting details of trusts. If I can ask Racquel, if you can perhaps just weigh in on the litigation side of it, and then Seugnette, perhaps share some of your experience in terms of getting information on trusts from the master. Racquel, if I can hand over to you.
So in understanding, a trust is not a company. So because a trust isn't a company, the Companies Act doesn't apply. So in fact, you need to bring an application against the trust to have the trust dissolved. So you can't liquidate a company, because by liquidation, you are bound by the Companies Act. And in sequestration, and that's similar. So you would have to essentially dissolve the trust.
Excellent. Thanks, Rex. Seugnette, and from your side.
Remember to add to that, so continuing on that, it also then implies that they aren't the same insolvency and liquidation sort of protection that we have for an individual or a company or whatever. But remember, the trustees would in those cases be considered to have acted negligently if they overextended the trust and entered into contracts and agreements where they didn't have the assets to back it off, or didn't pay service providers. And then the risk for the trustees comes into play again, where they are personally liable for the liabilities of the trust if they act recklessly in those instances.
Excellent. Thank you, Seugnette. Then I've got two procedural questions. I see Annette has weighed in with a very, very good question, which she actually had in the registration as well, which we'll get to a little bit later. Can we talk briefly, guys, just on the removal of a trustee? I've seen it pop up a few times what is the procedure? Nelly asks, if you're not happy with a trustee and you want them removed, what is the process? And obviously, this is something, Rex, I think you're tired of debating it this week. But anyway, let's not go into that. But, from your side tonight, is it something that you can do through the master, or is it specifically a court process?
So as I mentioned earlier, everything pertaining to a trust is set down in the trust deed. So the trust deed will guide you through those steps. There would be certain grounds and occasions where a trustee can either resign their position, and then obviously when asked to resign, it's one of two. Either it's a professional trustee that can gracefully step aside when they are no longer wanted. But remember, you also, when taking up the position initially, have an obligation to look into the opposite of the alter ego. So if you're being asked to resign to suit the needs of someone else because they don't like you saying no, then it would actually be reckless of you to resign. So you have to look at the circumstances around why you're being asked to resign. If you either don't want to step out gracefully because it's the end of a relationship or whatever, but there's no legal compliance issue if you're resigning, then I guess it will follow the court route. But yeah, the trust deed guides you through those steps, and to amend, procedurally speaking, to amend the letter of authority through an application to a normal application, not a court application, to the master's office is an everyday event, as long as the parties are willing to part ways. There are certain instances where a trustee has to resign because you are now declared insolvent or delinquent or whatever. So there are certain instances, but those are also set out in your trust deed. I guess the answer to the question we go to Racquel to ask if none of that happens peacefully and easily, then we go to court application, and I think then it becomes exciting.
Yes.
I think also on that, you also must once again look at your trustee. For example, we're dealing with a matter now where we can't simply just run to court. The trustees make specific provision for mediation to occur first. So if you are at loggerheads with removal of a trustee because they're acting outside their fiduciary duty, remember that you must look at your trust deed, and your trust deed sometimes guides you on how to deal with that.
Absolutely. Trust deed is the Bible, as Seugnette said also in her presentation. Then let's go into Annette's question. Sorry, Annette, I see it's actually a different question from the one you had, and we'll deal with both. I'm burning a lot of goodwill with my speakers, but I'm sure I've still got a little bit left to burn. Annette asks, what happens when a property is placed into a family trust? The husband and the wife are trustees, kids are beneficiaries. The parties have spent 3 bar renovating the home, which is in the trust, and it's now worth 12 bar. In the divorce, is that taken into consideration the improvements on the asset or the money made out of the asset during the marriage? The parties are married with ANC with accrual. Now, obviously, Annette, that's quite a complex one, which I think it's quite difficult without really delving into it. But I think, Racquel, if you can maybe just very briefly elucidate on the principles, the questions to ask, and not necessarily the answer to those questions, if you wouldn't mind.
So I think there's 2 approaches to this matter. Either you can remember, we can also look at the actio communio dividendo here, because they are both the trustees. I can't recall if you said there's a 3rd trustee there, Merv, but if I recall, there's only...
It seems that it's just the wife and the husband from the question.
So you can bring an actio communio dividendo in respect of the division of this asset of the trust. And remember, with regards to improvements in the actio, that improvements, if you want to reclaim those improvements back, you have to look at whether those improvements were reasonable and necessary. If they are, you are more than willing, you're more than happy to include them. If not, unfortunately, you cannot claim those back. In terms of the trust, I think it goes back to our question of this alter ego. And I think you've got a difficulty there, because it sounds like you're going to have to look at, once again, whether the one trustee is actually exercising de facto control over the trust to the disadvantage of the other trustee. But bearing in mind, the other trustee has a fiduciary duty. She cannot now just say, well, I was a trustee, I just sat back and I didn't know or do anything.
Yeah.
Was she then bullied into always accepting resolutions? Was she just disregarded completely when meetings were held, or were meetings just never held? So you really have to look at the questions, and we go back to my my questions in terms of alter ego. Let me just find my notes here. And we look at, you know, was there an intention to deceive third parties, or has any of the beneficiaries benefited from this trust? Has she benefited from this trust?
Yeah.
How was the trust purchased? Did they both put money into the purchasing of this house? Did they both put money into the improvements of this house? Look at the intention of the trust. Look at the trust deed and how the trust was meant to function. Are there loan accounts in this trust? So there's, and I think go back to my presentation where I said you have to unpack absolutely everything, and you have to look at unconscionable abuse of the trust through fraud, dishonesty, and improper purpose.
Absolutely.
Sorry.
No, go for it, Seugnette. I wanted to make the point on the financials, but I'm actually going to ask you to make that point.
That's exactly it. If you look at the core of it, of the day-to-day administration of a properly operated trust, there should be properly resolutions and minutes noting everything. And especially the loan accounts. Where did the extra 6 million or 4 million or whatever came from to do the improvements? It should be on loan account, which in return is assets in the estates of the two parties. So even before you go into the litigation side of things, practically looking at the proper records of account, the proper annual financial statements, resolutions, it should tell the story accurately. It's only when the documents doesn't tell the truth that we go into litigation concerns. But also, if you remember, the basis of this entire thing is that trust assets are kept separately from estate assets. Then asking the questions whether now the property has increased in value because of the fact that the property has increased in value is what you wanted when you set up the trust. Don't now forget what you wanted 6 years ago. That happened within the trust, not within the marriage. So it's only when you can prove, like Racquel said, bring facts to the table that there's a maladministration, there's misuse of powers, then it becomes a litigation matter. But as long as the trust was operated correctly, it's not an estate or matrimonial issue, it's a trust issue with proper paperwork and loan accounts that will reflect in the asset base of the now divorcing spouses.
Absolutely. I think you highlight something very, very important there is the role of trusts. Racquel and I have a few matters, without going into the facts, where we are either acting for the party being impugned and or for the party impugning the other party. And in many of these cases, the one impugning a trustee as a alter ego or abuse is actually a trustee themselves as well. And the question then arises, do you not have an argument of estoppel, saying, well, you've gone along with this. Can you really complain now? I would like to highlight a scenario here from Corin Buerta. Corin, at this stage, it's a very long question, but she's one of my favorite people. She took 40 minutes of her time and gave me such beautiful guidance on a Durban matter, on their trial readiness process, and actually put me in touch with a wonderful correspondent that side as well. I'd be remiss if I didn't show some love to Corin when mentioning her question. It's quite a long one, so please hold on to your hats, ladies and gentlemen. Scenario. Trustee 1 is the trustee of 2 trusts. His first wife is a trustee of the first trust. And the second wife, it's a polygamous marriage, so these concurrent wives, not sure, okay, is a trustee of the second trust. He is beneficiary of both. He purchases an immovable property in the name of the second trust, using money borrowed from the bond over the immovable property of the first trust. When the second marriage ends, he launches an action in his capacity as trustee of the first trust against himself and the second wife in their capacity as trustees of the second trust. When the second wife defends, he says she cannot defend because the trust deed requires both trustees to consent to the trust litigating. Any thoughts? Sure. I think that it's a deadlock scenario, Rex.
Definitely sounds like a deadlock, and I think you definitely need to look at what the trust deed says.
Also,
because how do we manage this deadlock?
Yeah, Absolutely, and one has to look at their conduct as well in this. I mean, if he is raising that in a mala fide way, surely the court has an interest to override him. Corin also being on the group, do you mind, Rex, if Corin contacts you directly via WhatsApp to debate? Corin, obviously a big one to debate. You're obviously welcome to get in touch with Racquel. I think let's do 2 more questions, and then I'm going to leave our speakers in peace for the remainder of their Friday afternoon before burning too much goodwill. But obviously both of you are on the WhatsApp. Can I put the call out? Are people entitled? Can they ask some questions on the WhatsApp group? And we will chime in as far as possible, obviously, just to not burn too much time. We've gone 20 minutes over already. Here's an interesting one. The scenario that the question really brings it's twofold. I'm actually going to combine 2 questions. Question 1 says, to what extent are trustees entitled to nominate or change beneficiaries? And then the second one is, what is the discretion when there are 2 beneficiaries and both of them really say, well, I don't actually want this property being held in the trust anymore. We are the only beneficiaries. We want the trust actually to be dissolved on the basis of impracticability. So Seugnette, can I ask you perhaps to just talk to us on the amendment of the beneficiaries, and then Racquel, if you can address the impracticability thereafter and dissolving the trust potentially.
Yeah, so the amendment of beneficiaries is similar to any other amendment to the deed of trust, and that would be dealt with in terms of your amendment clause in your trust deed. And the amendment clause will tell you, as long as the founder is alive, he or she should be a party to any amendments made to the trust deed. And then it will also go into saying whether the beneficiary should be party to the trust deed. Now, the effect is that sometimes the amendment clauses are silent and sometimes they are contrary to, let's say, common law. So it would come down to, if a beneficiary or a class of beneficiaries already accepted benefits in the trust, they have now become a party to the contract. Remember, when we set out the stipulatio ulterior at the beginning, we said it's a contract between 2 parties for the benefit of a third. But once that third accepts the benefit, it becomes the 3 part, is a party to in a contractual law sense. So if you then want to make amendments to the trust deed, then all of the beneficiaries should be party to the deed of amendment. So it's always easy to add. But to remove someone is a little bit more tough if you need all of the beneficiaries to be party to the deed of amendment. Like I said, as long as the founder is alive, he or she or it should be party to the deed of amendment. And in the fiduciary responsibility of the trustees, you can never do anything like that to the prejudice or detriment of your existing beneficiaries. So for you to misuse your seat as trustee to add someone else, that's not the benefit or part of the family or whatever of the other beneficiaries, that would be reckless. So within the scope of what you are afforded in terms of the trust deed, it can be done, and it would just be by means of a deed of amendment. Deciding who the parties of the deed of amendment would be determined by the trust deed, except if the trust beneficiaries have accepted benefits, then they automatically have to be party to the deed of amendment. If they don't consent, then it cannot happen.
Sure. Not quite as easy as it sounds. Not quite as easy as it sounds. I have a client who's a trustee who says, I want to just remove them because I'm not angry with them. Not quite as easy.
Yeah.
All right. Rex, 100%. All the best. Racquel has just informed me she's got something to deal with her urgent. Racquel, thank you so much for your time. I really appreciate it.
Thank you very much. Sorry, Mervyn. Sorry.
No. Please, thank you so much. I really appreciate it. All the best, and we'll chat to you on the group.
Thank you. Bye.
Right, so now I think then let's, between you and I, let's quickly debate this issue of bringing a trust to an end. And I see we've got about 25 people left. Obviously those who are not on their way to the pub yet and would rather learn on a Friday.
Fast during the day.
Absolutely. So when can you really bring a trust to an end? Obviously, the trustees, I suppose, can take a resolution. But if the trustees are not willing to take a resolution, there are obviously, and you're going to think I'm very fancy. I did some reading in honoré on trusts this week, pretending to be a fancy fiduciary lawyer and not a litigation dog. But I know there are a few grounds, for example, impracticability, impossibility. Could you expand on that a little bit?
Well, once again, as everything else, the trust deed. So the trust deed will have a termination clause that says upon this or that person passing away, the trust should dissolve, and it should dissolve in these percentages to these individuals. So it can set out specifically who the capital should go to, in what ratios, or if there aren't any ratios, whatever else. So the trust deed will tell you when it must be terminated. If it's silent, or most often in modern trust deeds, you won't have you won't have a trust deed that's too prescriptive, and then the trust deed would simply say at the discretion of the trustees, whenever the trustees deem it fit, they can terminate the trust. And in termination of the trust, it means bringing the finances up to date, which should obviously always be up to date if you fill in your role. Then they will decide in terms of the distribution clauses how to distribute the assets and bring it to a zero balance, take it to the master's office and terminate. But there are obvious places also where the trustees will use their discretion. So like you mentioned, where the assets of the estate of the trust doesn't make it worthwhile anymore to run the costs of operating the trust. Now our expenses are more than our income or our capital, whatever. We are not acting in our fiduciary capacity anymore because we're not benefiting the beneficiaries anymore. So it would be prudent for us to rather terminate. So none of that would also go through litigation side, because it would, in the exercise of a trustee's responsibilities, be obvious when the time has come. Beneficiaries cannot make that call. Beneficiaries cannot come to the trustees and say, I'm now hurtful for the trust, can we get out? They can't do that. They can obviously raise their concerns, they can approach them in writing, but that is absolutely at the discretion of the trustees. Beneficiaries simply do not have that right or opportunity, just because they also don't have any rights or expectation of a benefit from the trust. Depending on the type of trust. If it's a vested trust, a little bit different. But in discretionary trust, you have no right to receive any benefit from the trust. You only have a mere expectation to possibly, because I'm part of a class. So beneficiaries cannot make that call. If the issue that wants to lead up to termination is a result of maladministration, trustees misusing the trust, then yeah, sure, then you can contact Racquel.
Look, I'm reminded of the old adage of an ounce of prevention is really worth a pound of cure, and
yeah,
I can certainly attest to that. 90% of the matters in trusts that I see are trusts that are traditionally not well administered, and you really get into a position where you sit with a very big gray area. I have one matter, for example, where the parties have not done financials in many years.
Yeah.
And recently, well, not as recently, but beginning last year, the parties eventually decided, in the context of a divorce, to start bringing the financials up to date. Now, what are the chances of parties going through a divorce agreeing on financials? Because there's loan accounts, there's all sorts of things.
You have to agree and you have to sign them off. Yeah.
Exactly. And then you sit with an independent who's placed in a precarious position, because they have to now weigh up. If they side with the one, the other will say that they are biased. Yeah. So under those circumstances, I would venture as far as say I have more chance of getting pregnant than trustees agreeing on financials ex post facto. I know I might look pregnant, but I'm not. But that is problematic, and especially in the
instances, it goes to application, and that is where it becomes sticky.
Well, that's the problem, because now you have to go to court and the court has to really decide. But is the court better positioned really than the parties? Well, not really, because you are sitting with a conundrum in an enigma. Then you can get experts to try and unravel the iPod headphones out of the pocket, which is all koekerasie, as you would say in Afrikaans, without having had the benefit of being involved with this trust at all. And it really becomes akin to playing Russian roulette in litigation.
Definitely, and I think that is where you'll note that the difference in tone between how I answer questions and how you or Racquel will answer questions is, from my side, not being a litigation attorney and absolutely dedicating my career towards fiduciary matters, estate planning and trust administration and trust operations. If you do your job properly, you shouldn't be ending up in litigation. And if you do end up there, your records and your statements and everything should be absolutely spot on. So that is where it comes back to the importance of a proper, professional, independent trustee. If you're going to play around in trusts, the benefits are great, but the risks are even greater if they're not operated correctly. And that comes back to the day-to-day administration. So if you're going to either advise your clients or personally have assets in trust, it should be perfect. And nothing short of perfect. And the moment that that's not true anymore, then personally as a trustee, then I resign as trustee, because you can also just not step away. You have a responsibility to see things through. But if we get instructions from new clients of trust like the one that you just described, where the financials are 10 years outdated and nobody knows where the deeds are and whatever, then if we get back to our very first question of the day, what are reasonable trustee fees? Then our fee reflects that when we say, we'll take on your trust at a normal fee per annum based on risk and responsibility, but for the take-on process, we have to now do 10 years of, or arrange, we're not accounting officers, arrange to have 10 years of financials brought up to date, do resolutions, do minutes, figure out what's going on here. And that is going to, at an hourly tariff, cost you. So once again, either you do trust and you do them properly, or you don't play around with them.
Yeah, no, absolutely. You can't be substantially a trustee. I think there was a beautiful case years back. I think it was a politician who had a criminal case against them, and their attorney stood up in court and said, well, my client cannot be here. They are substantially pregnant. You cannot be substantially a trustee. You have to either be a trustee or not. So I see we've got about 27 people still left. These are the guys who I think have really done their time and are entitled to the Cliff Notes version. So we've really done quite a lot of in-depth stuff. So now between you and I, shall we give it a crack to give our top 5 tips to not getting in trouble with a trust? What do you say? Are you up to it?
We can definitely try that. I think I'm sounding like an old record already. For me, it's definitely understanding the trust structure. It comes back to that triangle. If you don't, you need to understand what you're getting into. For a client and for advising, number 2 would be to understand you're giving away assets. For any of my clients, none of my clients would even dare to say around a table, my house or my this, or but it's only a structure. No, you need to fully understand the implications of surrendering your assets and control to an entity that's not yours and that you no longer have control over.
Excellent.
So if you don't have an understanding of how the structure work with the stipulatio altieri, and secondly, you don't understand the importance of relinquishing control, then you're going to get into trouble. And then furthermore, proper administration, understanding your trust deed, I think 4th would be understanding the deed, because no 2 deeds are the same. Even within the same company of the same template, no 2 deeds are the same. And as a trustee or a founder or beneficiary, if you're privy to the information at that point, you need to understand what you can and cannot do. And every time an action comes up and you need to act, you have to go and check again. Don't act outside the scope of your trust deed. Know your deed off by heart. That's just the 4. I think.
Excellent. I want to add.
Number 5, partnering with brilliant accounting officers. Respectfully, just as attorneys, just as I'm not a litigation attorney, not all accounting officers are equally as schooled in dealing with trust books. They are very specific and very specific what they should be like. So for a trustee or for a family group to partner with an accounting officer that really knows their stuff, so that you don't get into trouble with SARS. Because remember, these topics come up in divorce, insolvency, and when SARS is interested. Those are the 3 people that you need to avoid.
When the 4 points the fan, in other words. I want to add to, and I think it ties in with yours, but much more. How should we say, unsophisticated, as is my modus operandi. Do resolutions, do them thoroughly, do them frequently. Table everything. As a litigation attorney, that's one of the banes of my existence when dealing with trusts. To try and understand, for example, loan accounts. Let's talk about our question with regards to improvements earlier on. If you have a resolution saying, I'm going to improve the house by doing X, it will be as against a loan account for this amount, done. You have no issues. And I would say the second one is do financials, do them properly, do them annually, and have all the trustees sign off those financials and agreement.
I agree, and I guess where your and my worlds collide is when my clients end up in the litigation side in your office. If I did my job properly and the resolutions and the minutes and everything is in place, then your case is already made. So then when you do get into trouble, your litigation attorney would actually be able to help you because the record, proper records of accounts is there. So, I think that is the golden thread, is administration.
Fantastic. Administration. Right. I don't see any further questions on the thread. I'm going to wrap up now. It's now 20 to 1. Thank you so much for everyone who attended today's presentation. Seugnette, especially, thank you. I really appreciate your insights in the presentation today. I'm going to be sharing, for those who are on the WhatsApp group, I'm going to be sharing the email addresses on the WhatsApp group. If you have any further questions for Seugnette or for Racquel, I see Racquel's just trying to phone me. I think her situation has calmed down on her urgent. They are on the group. Please pop some questions on there as well. Reminder, a few calls to action. Have a look at our upcoming webinars. The accrual one on Tuesday, I'm so excited for. Stella is just incredible when it comes to doing the financial stuff. I'm looking forward to hearing what she has to say. Then for those of you who would like to speak on a webinar, present something, please do get in touch with me. We are very open to giving as much opportunity to those who are involved to learn as possible. So from my side, once again, thank you everyone for attending. Thank you, Seugnette. You've been an absolute star. I owe you big time. Lots of goodwill earned and or burned today. So thank you so much. Thank you for everyone giving feedback, and we will see you all again on Tuesday and on the WhatsApp group a little bit later. So have a wonderful weekend, everybody, and we will see you in the next one.
Bye.
Cheers.